to a CDR FYI and Oscar webinar. My name is Jason Grillo. It's good to see so many of you here today. This is the start of a series of webinars that CDR FYI is going to host to walk you all, our carbon removal community, through the Oscar document. What we're going to do now is have, we've got Peter Mayer here, as well as the Oscar team, and also Alexander Rink from CDR FYI, who I'll call on in a minute to talk a little bit about CDR FYI's role in this. What we're going to do is walk through the Oscar Open Standard Carbon Removal Offtake Purchase Agreement document that was launched about 3 or 4 weeks ago at a COP30 virtual event at the CDR 30 platform. This, for those of you who are newer to Oscar, this is a new document, an open standard document that aims to remove friction points that otherwise may delay the execution of carbon removal credit, durable carbon removal credit purchase transactions. What we want to do in this webinar is, again, walk through the details, some of the nuts and bolts of the document so that you as the CDR community have a better sense of what the document is and how you can use it on a day-to-day basis. Happy to say it's already been used in several situations, so there is field experience with this. Our webinar is being recorded today. So yes, this will be made ultimately as a this webinar will be made as a publicly available resource. Also, after Alex speaks and Peter speaks a bit about Oscar and the document, we're going to open the floor up to questions from you so that we can hear some of your comments, concerns, and feedback about what you think about the document so that we can have this be truly a working document, have it be an open source resource for the public to use as a freely available piece of contract paper. Just to be very clear too, this does not constitute legal advice. So please do work with an attorney to evaluate the resource. Again, freely available, publicly available, and not to be constituted as legal advice. Right, so with that, I'm going to actually ask Alex Rink to come on now. And Alex, feel free to unmute yourself so that you can talk a little bit about CDR FYI, the role that CDR FYI is holding in this, and where you see Oscar going as the on the hosting site. Oh, yeah, please.
I think he's got. Could you help him, Jason? I think he.
Sure. I'm asking him to unmute. Whoop. Oh. I can ask to unmute, but I can't actually do the unmuting. Awkward. Okay. So Alex, you can type in the chat if you wish, but we can feel free to go around and have Peter start, and then once we can come back to you. Okay, great. Peter, good to see you. Why don't we have you walk to the document? Oh yeah, by the way, also to recognize the contributions of other volunteers in the Oscar team, Mr. Glenn Morley, who's on the call, and also Elena Perez-Solis, and also Laura Katayama, who just joined the volunteer team with Oscar. But Peter, please take it away.
All right, great. Thank you, Jason. Maybe we'll just jump right in. And I'm going to share my screen. And then maybe the best way is, so can this be seen by everybody, what I'm having on my screen here?
Bingo.
Excellent. Okay. So to give everyone sort of a little bit of a background. So this is this is Oscar. The template we developed over the last year, following input from various stakeholders, suppliers, buyers, intermediaries, lenders. There was a process until we got to this version that was published. Sort of the initial version we had was longer, more detailed. There were more provisions in there. And one of the feedback that we get from many stakeholders is that it would be too long, particularly since we intend this document to be primarily used for first-time buyers, or folks that are new to the CDR space. So there's a bit of an educational element to this document, together with the guidebook. And we didn't want people sort of to get overwhelmed when they look at their first offtake agreement. So what this is, it is a baseline where people can start from. It works, suppliers can use it, buyers can use it, intermediaries can use it. There may be in each of those scenarios, it may be appropriate to make adjustments. An intermediary might want to make some changes to the warranty provision, for instance. But all these changes can be done relatively easily in all kinds of directions. That's what we think. So this is a baseline where we can start from when we want to look at a CDR offtake agreement. The table of contents basically gives you a little oversight. What are the relevant terms here? Right, transfer of title, pricing and payment is obviously important. MRV is very important for buyers. What happens in a shortfall? There are various reps and warranties, and sort of other customary provisions that we have for CDR deals, public announcements, right? Reputational issues that could arise, events of default are obviously going to be very important. And the rest sort of is, let's say, sanctions, anti-bribery, corruption, depending on what kind of jurisdiction the project is, that may be important. And the miscellaneous provisions are pretty much standard for any kind of commercial transaction. So let's get into this a little bit more in detail here. And maybe we'll pick sort of just those, not going through every individual clause, which maybe self-explanatory at some point, but maybe pick the ones that are the most important ones. Maybe start here with price. So the default rule in an offtake agreement is payment upon delivery. Well, what this agreement does, it provides a few other sort of options or scenarios depending on where the project is at the time when this agreement is being signed. For instance, commercial operations might not have commenced yet, right? So if the project's up and running and is already generating credits and selling credits, it's relatively easy. But maybe there are scenarios where the project still needs to be developed and there is no commercial operation state. So what this clause does, it gives a few options. There may be other options depending on the scenario, depending on the individual circumstance. But I think this gives you a good idea how payment could be structured. The next thing that's sort of very important, obviously, is title transfer and delivery. Sort of at what point in time does title transfer? At what point in time does risk transfer? There's a distinction to be made between transfer transactions, when the credits are being transferred from one registry to another, and a retirement transaction, which typically occurs when the supplier retires the contract retires the credits, takes them out of circulation and retires them, either on behalf of the buyer or sometimes on behalf of a third party designated by the buyer. And there's an exhibit at the end of the agreement, sort of where the parties can check the box as to whether this is a transfer transaction or a retirement transaction. Bankruptcy and commodity matters, that's sort of mainly for U.S. transactions or relevance, to make sure that the parties can terminate the agreement in the event of bankruptcy. But that's sort of very, very detailed. Maybe we'll talk about the MRV plan a little bit. So what's critically important for every buyer in a CDR transaction is obviously that the credits are being issued properly, and that they are certified properly. And it is typically the supplier's responsibility to take care of that, right? To develop an MRV plan, choose the standard that should apply to this project, and then follow that guideline and until the projects are validated and the credits are verified. Depending on how long this takes, there is a reporting requirement that the agreement provides for, that in certain intervals here it says every calendar quarter, supplier needs to provide an update to the buyer as to where the project is currently at. There are different, you can see some of these things are in square brackets. It also depends on whether commercial operation has already occurred by the time this agreement is being signed. If commercial operation has not occurred yet, there may be sort of additional reporting requirements. So MRV, reporting, monitoring, verification, that's very important. So one clause I would like to get into a little bit more detail is the shortfall provisions. That's obviously a very important, maybe the most important risk allocation aspect in a CDR offtake agreement. What happens when the credits are not delivered on time? What Oscar does is it distinguishes between a generation shortfall and a delivery shortfall. And there are different kinds of remedies or different kinds of consequences in each of those scenarios, right? So a generation shortfall is basically that the project does not generate the CO2 removal that was promised, right? Say we expect that the project removes 100 tons by the end of this year, and that doesn't happen for whatever reason. It could be an issue with the technology, it could be an issue because of energy supply, it could be whatever, basically. For some reason, and it does not say here that it's due to the fault of the supplier necessarily. For any reason, the anticipated removal does not happen. That's a generation shortfall. A delivery shortfall is that the removal does happen, but the credits aren't being delivered to the buyer. That could be an issue because of the verification process, an issue because of an issue with the registry, right? And they are slightly different. There have been, in the consequences, there are some nuances here. this has been tested in the field, and curiously, when we represent buyers, we get a lot of pushback on these clauses from suppliers, which surprises me a little bit, because it's actually supposed to be somewhat supplier friendly. But I think because of the complexity of the clauses, maybe there is a bit of a misconception as to how this works. So if you look at these clauses and you read them, you might find them sort of a little bit confusing. So I'm going to break them down, right? Generation shortfall, the cause is the project fails to generate enough credits. This is typically because of operational or performance issues. Right? What are the makeup options, right? These are in here, 2.01b, right? The supplier can deliver the credits later, increase future quantity, issue replacement credits, right? And you can see here that there is some language here that makes it more difficult for the buyer to reject replacement credits if they are using the same technology. So this is a slight distinction to the delivery shortfall provision. And there is basically another difference is that unlike in the delivery shortfall, which we have down here in the square bracket, which means it should always be subject sort of to discussion. The generation shortfall does not have a penalty mechanism, right? Whereas the shortfall makeup does have that. The reason for this distinction is basically that we're saying, sort of from a buyer's perspective, that a buyer would say, okay, we recognize that this is a nascent industry, and we acknowledge that. And we are prepared to distinguish between a shortcoming in the generation of credits, because there may be issues beyond the control of the supplier. And the technology isn't advanced enough yet. It's all, we can't be really, it's not technologically proven yet, or for whatever reason. Whereas when the credits are being generated, then there is sort of a little bit of a harsher liability on the supplier to say, well, when you manage to generate credits, then you got to find a way to deliver them to the buyer on time. So this is a nuance, right? If you use that, you got to be aware of that nuance. Like I said, most suppliers have seen it, said get rid of this generation shortfall, and we just use it as a delivery shortfall for whatever reason. Is that fine? If that's what you want to do, it works for the buyer, right? So I just wanted to spend a little bit more time on this one here to show the nuances and also explain why there is a nuance, and that it is something that actually works to the benefit of the supplier, or is at least designed to work to the benefit of the supplier. In general, I would say the agreement is sort of slightly more buyer friendly, and the reason for that is simply because we want to get more buyers involved in this market, and we can only do that by putting agreements out there, or by using agreements that lower sort of the risk that the buyers typically take when they anyway think that they are sort of I'm not talking about Microsoft or Frontier or very sophisticated buyers who know this industry very well. But if a new buyer gets into this space, there is a lot of sort of internal discussions and convincing and explanation and educational effort that people in an organization that want to convince their CFO to buy carbon credits, there's a lot of hoops they need to go through. And if we have contracts out there that are overly supplier friendly, that makes it even more difficult. So what this is trying to do is it tries to protect the buyer, but it also appreciates that suppliers are startup companies, and this is a nascent industry, and we cannot overburden suppliers with obligations they may not be able to fulfill. But where it's appropriate, we can sort of acknowledge the specific issues and challenges that the industry has, and this clause is one of those that tries to accommodate that. Reps and warranties, 8.01, we don't need to talk about that. This is like typical, you basically see them in any kind of commercial agreement. These are standard reps and warranties. Parties have the authority, are probably incorporated, have the authority to sign, aren't bankrupt, and so on and so forth. 802 goes a bit more into the supplier-specific warranties, right? This is more like with respect to the project, right? It has been proper, so the supplier should, represent that the project has been properly validated and registered. Everything's been done in accordance with the law and the applicable carbon standard, material, environmental risks, and so on and so forth. Now, if you are in an intermediary, you look at these clauses. Again, Oscar for now is deals with the situation where a buyer purchases carbon credits directly from a supplier. If you are an intermediary, you want to look at these clauses and maybe put a knowledge qualifier in there, right? Because as an intermediary, you're not involved with developing the project, and you don't have that first-hand experience. So you might want to say, to my best knowledge, the project has been validated and registered. But that's sort of a small change to make depending on the particular facts and circumstances. And that also sort of ties into what Jason said at the beginning. When you use this agreement, you got to get a lawyer involved who guides you through this and who knows about your particular situation and can make small adjustments and amendments where they are appropriate. This is not a catch-all scenarios agreement where you just say, okay, thank you very much. Where do I need to sign? There's a bit of there's a thought process involved in getting this over the finish line.
And Peter, if I may, we do have Alex Rink here for a couple minutes. Maybe this might be a good time to just interject how this document can be interactive and what the hosting on CDFI means for this. And then we'll get back to the Article 9 and beyond.
Thanks, Jason. And thanks, Peter. And apologies, everyone, for the extreme technical difficulties I was experiencing. Yeah, I think Peter summed it up well there, and I think Glenn made a good point about a generally low level of understanding in the market. This is a nascent market, and so everyone is starting from scratch, and everyone in their understanding of the legal implications and how to structure their agreements is pretty much starting from scratch. And that can be quite expensive, frankly. And not only is it expensive, but it also leads to a certain amount of distrust, where each party protecting, legal counsel for each party protecting their respective interests of their clients, it maybe doesn't really understand some of the terms and needs to educate themselves. So the purpose of Oscar is to create an open standard, as Jason said, that everybody can depart from. As Peter said, it's not something where we expect that it's going to be 100% applicable in every situation and be able to use it out of the box. but it at least gives you an accelerant in your legal processes so that your counselors have something to start from. And there's an accompanying guidebook, which is an incredible resource that outlines a lot of information about the various clauses. So this is meant to be, as we've all said here, an open standard. We are hosting it on cdr.fyi. We are actually turning it, it's currently in PDF form from the blog, but we are intending to make it a series of web pages. And we encourage everyone to provide feedback and suggestions. If there are things that you run into in your particular agreements or transactions that you feel have been very common that you feel are not covered in OSCAR, we encourage you to bring them forward. So I believe, and I know that this is one of Glenn's thoughts in coming up with the initiative, that essentially there are building blocks that are required in any new industry, and we believe that OSCAR is emerging as a standard around the legal template that we can use for transactions, again, with minor modification as required, by each party. We will know that we have progressed as an industry when we get to an agreement that everybody can literally take out of the box and just use, and that any modifications to it will be the exception rather than the common practice.
Okay. Thank you, Alex.
Thank you,
Much
Jason.
appreciated. Okay. So going forward, just one other thing. So please continue to ask your questions in the chat, and Peter will continue to walk through the document. And in a little bit, we'll get to your questions as they're coming up. Okay, see a lot more stuff coming on right now. Peter, please continue.
Right, maybe just to second also what Alex said, and for those who listened to the interview that I had with Simon Jones yesterday, we put this out there sort of as a tool for market participants to use, and also to collaborate in the further development of this document, right? We have, there are sort of other agreements out there that have been published. For instance, the Frontier Agreement, the Microsoft Agreement is very well known as well. The difference of this one is that whereas Frontier said, hey, this is the one we're using, it works for us, and we're giving it to the market. That is great. But it is sort of a very buyer-centric approach for a particular set of buyers. Right? VC-funded software companies primarily. And what we're trying to achieve here is to create a collaborative effort of every stakeholder in this industry, buyers, sellers, intermediaries, lenders, lawyers that are getting into the space to contribute to this. And on the website of cdr.fyi, there's the possibility to leave comments. You can say this clause is fantastic, this clause is crap for this and that reason, and we have this kind of experience, and typically we get a lot of pushback on this clause, and have you considered this aspect? So we encourage people really to contribute to this. This is not, for us, we're looking at this from OSCAR's perspective. We're looking at this that it's basically just starting. We're putting it out there, and now the real work begins in sourcing comments and experiences from market participants. Okay, so the remaining, let's quickly go through the rest of the agreement so that we have sufficient time for questions. Public announcements, that's typically an important aspect in CDR, especially buyers they sort of want to be sometimes a bit cautious, right? We've all heard about the term green hushing. So not everybody wants to find its name in the newspaper that they bought carbon credits. Reputational events ties into that. A buyer would typically like to know that once there's an issue with a project for environmental reasons, or safety non-compliance, they want to know about this because this also has a potential negative impact on their reputation and standing in the market. Events of default is another sort of key provision in any CDR purchase agreement. This one is drafted again in a way that gives a buyer a reasonable amount of security, while taking into account that not sort of every minor issue on the supplier side causes an event of default, right? If you, for instance, when you look at the delivery shortfall or generation shortfall, this now suggests sort of 25%, at least 75% of the credits need to be delivered after the cure period, which we were just looking at 7.01 and 7.02. So if there's a cure period in 7.01 and 7.02 for generation and delivery shortfalls, if after that cure period there's still 25% of the entire contract quantity missing, that's an event of default, right? This number can of course be adjusted downwards and upwards, but it's supposed to make sure that not every single issue leads to an event of default. Then there are a number of no-fault termination events, right? These are typically force majeure events, a change in law. Now, if you want to use this, just one example, if you want to use this agreement for a spot transaction, you can basically get rid of the force majeure event, right? If you get a lawyer, he would tell you, say, you don't need a force majeure event if you sign an agreement today and you're buying carbon credits the day after tomorrow. Right, so these are things a lawyer will help you with. Indemnification clauses are pretty much customary, I would say. Limitation of liability. These are all customary provisions. One thing that will give rise to discussions are the percentages. Right, up to what amount is a supplier liable? That's subject to discussion. It's being left blank here. Confidentiality, again, is a pretty much customary provisions. IP rights are typically very important for suppliers. They want to make sure that their IP is being protected. Insurance and project operation. Supplier needs to covenant that the project is maintained in accordance with all applicable laws and the applicable carbon standard rules. Sanctions and anti-corruption provisions, also sort of quite customary in CDR transactions, considering that the jurisdictions the projects are sometimes placed in. The miscellaneous provisions, we don't need to look at those. They are basically as in any other commercial agreement. The definitions are a part one should really pay attention to. We don't need to go into the details here, obviously. But the feedback that we've gotten since this has been launched is that many say, oh, these definitions have really been sort of extremely helpful. And we've used them in our context as well. it's really very clear that people understand sort of what they're talking about, right? It's like, when is a credit being generated? This is for instance, this is just an example, right? Generation. What is even a credit, right? So there are some very helpful definitions in here, I think. It takes some time to read them. And at the end of the agreement, you typically, right here, this follows sort of the pathways, follow the CDR.FYI standard. The delivery schedule, this is just an example. They can also be more detailed, depending on over what period of time the contracts are being delivered. There may be different kind of projects, and that's pretty much it. So when you look at the table of contents, you pretty much have every kind of provision that you should find in any CDR offtake agreement. If you don't find these headlines in a CDR offtake agreement, the wording might be different, but these are areas that should be covered. There are some areas that are not covered in this agreement. There's no most favored nation clause in there. There's no right of first refusal in there. The guidebook provides some explanation as to why this is not in here. Again, some of this was because people said the contract is too long, and it should be shorter. So there may be additional things you want to put into an agreement. The guidebook can help you identify those.
All right. And with that, I think we're into the Q&A section right now. Peter, I want to pick up on a question that I have just from my own experience in negotiating carbon removal contracts and in carbon markets. Say I'm a buyer and I'm accustomed to not necessarily durable, trying to figure out durable carbon removal, but I am familiar with, say, RED Plus and REC and ARR and IF reforestry and afforestry and improved forest management projects. I've got experience with that, or even from intermediary experience with those. How is this different from that type of contract that might know as well? There was a question earlier about how is this different from the symbiosis agreement in particular. But again, for people who are buyers or intermediaries viewing this, and they're accustomed with carbon credit contracts that are not necessarily durable carbon removal, how is this different?
It's not significantly different, right? If in an NBS scenario, there are aspects maybe you want to pay particular attention to with respect to MRV, monitoring periods after sequestration. There may be a longer period involved, for reforestation or afforestation project until the trees have grown. And there's only so much you can do because it all depends on nature. So you have to, thinking about this in the context of an agreement, you have to think a bit more in longer term, right? You might want to pay additional attention, and particular attention to project monitoring requirements, reporting requirements, right? A buyer might want to know, where's this project at? So, and it is, as in any contract, it's anyway, I think, always very important to point out that there needs to be sort of transparency is key, right? And there needs to be good communication between the parties involved. Find a good rapport with each other, communicate, disclose issues you're running into, delays. That helps build trust and integrity. And the best contract helps you only so much if the parties don't get along with each other and there is some kind of mistrust. But purely from a contract perspective, you can basically take this contract and just think about, okay, what are the particular issues in an NBS scenario? And then you think, okay, we got to be a bit more detailed on the monitoring period. Maybe more detailed than this agreement is. But there's nothing conceptually new. And that's sort of the beauty about this agreement, I find, and why we said it's sort of a baseline. You can basically, the way it's now, it's closer to a durable CDR solution than it is to a nature-based. No question. But if you have an NBS project, you can take this agreement and just expand on a few aspects. You don't need to get in entirely, you don't need to start from scratch.
Right. Great. Thank you. In that vein, Miriam Makani, if you're available to unmute yourself, you had a question about how this has been used in experiences for across different kinds of CDR credits. Miriam, are you able to unmute?
Yes. Thanks very much, Jason. Can you hear me well?
Yes, please do.
Wonderful.
Go ahead.
Thank you very much. You all had it absolutely right. This is a nascent market. It's new, so there is a lot of learnings to go through. My question was specifically around, this is going to be more like a generic offtake agreement. So I was wondering, during the development process of it, did you have a chance to benchmark it with some of those offtake agreements that have already been executed and are in place? And why I'm interested in this is because I feel like there should be differences when it comes to different types of CDR credits, whether it is direct air capture or mineralization. So I'm just curious to hear from you about the learnings that you've gone through.
Right. So this agreement, it has been used in the field already. Already hundreds of thousands of tons have been purchased using this agreement across various pathways. Mainly biochar, but also direct air capture, marine carbon credits, ERW. In each of those scenarios, there have been sort of different kinds of experiences and adjustments that were made, taking into account that it is a different pathway. Nothing of this changes this agreement sort of structurally or conceptually. But for someone who, if you are, say, selling direct air capture credits, you may be more hesitant to accept a price adjustment in case of a delivery shortfall if credits are delivered late, because that's the challenge that the industry faces at the moment, right? So depending on what kind of depending on the pathway you're dealing with, you will see sort of different kinds of discussions. And at the next step, this is way down the road, once we've also digested and dissected all the learnings that we've had, and as this market grows, maybe we'll have one day, say, use this for biochar, use this for direct air capture, use this for marine. But it has been used across pretty much all pathways, and the adjustments that had to be made were minor. I've had I've had experiences with this from sending it out to execution 4 weeks, which is pretty quick for a CDR transaction. So it has helped to speed up the process tremendously.
Cool.
Thank you.
That's what we like to see. Sherry Segal, you had a couple of interesting questions to ask as well. Feel free to unmute and ask if you can.
Sure. Thanks a lot. Thanks so much, Peter. This is really helpful. And I just had a couple questions that I think we'll talk about later anyway, but so I've been hearing a lot across, the sector, and this has been, that power purchase agreements have been used as a template for some of the financing deals that we've seen in this sector, just because, some of the big financiers really understand them and are comfortable with them. And, one of the recent deals that JP Morgan did, they used Chestnut used as a template, a PPA. So I was curious if you looked at PPAs and kind of how this template compares and if there are any significant differences. And then I had another question, which is a little bit more kind of nuanced, but just on the generation shortfall, this is kind of the big issue, right? And especially for using these agreements in the nature space, it's like this requirement increasingly that off-takers have in order, and also in terms of order for off-take agreements to be bankable, this delivery of like-for-like credits, and you use the term, same technology, but I'm just curious because in most of the nature-based projects, if there is a shortfall because something happened, execution-wise, it would be very difficult to deliver for most of these project developers to deliver like-for-like credits. And insurance doesn't cover that, right? So I'm curious what happens in the case of that. Is that an event of default? Is there like a payment, and is that payment tied to like the original prepayment amount, or is it tied to the value of the credits, kind of at the time of under delivery, right? Because that could bankrupt a project developer. They're not going to have credits that are, worth tenfold what they promised at, 10 years ago, right? Anyway, those are two very different questions, but thank you for addressing them.
Sure. Thank you. So maybe with respect to your first question, power purchase agreements, maybe one of the main elements that we are looking at when we compare an offtake agreement with the power purchase agreement is sort of with respect to bankability of the project. This is relatively easy in a PPA when so you got a power plant that's going to generate a certain amount of electricity, and you pretty much know sort of what the price will be and how much electricity will be used. And that makes it relatively easy to get financing for these kinds of projects, which are of course very capital intense, way more than a CDR project. So what we've done here is we've looked at and saying, okay, what sort of does a financial institution need to provide financing to a power plant, right? And how can we use those learnings with respect to an offtake agreement? So we've spoken to financial institutions about this, and sort of the generic response that we got was this is an agreement that they could work with. You're not going to get a definitive response from a bank and saying this is perfect, but it is sort of something that they can work with. So what you need is you got to make sure sort of that the offtake agreement sort of is long enough so that that the income that's being generated from the sale of the credits allows for the amortization of the debt, right? That's one of the elements. You gotta have sort of a fixed price on the carbon credits. Price adjustment clauses or most favored nation clauses, which this agreement does not contain, are difficult for a lender to deal with. And you got to have only very restrictive termination rights for the buyer, right? Only in like limited circumstances of event of default, so that a bank can be certain that a buyer cannot walk away too easily from this agreement. So there are some learning. So in short answer, yes, there are some learnings from a PPA that went into this agreement. And we've spoken to some financial institutions. The general feedback we've received is that this is something that they could work with. With respect to your second question, I mean, so that goes very much into detail as to how you would sort of cover that risk in an offtake agreement, right? You could have a longer cure period in an NBS, right? In an NBS scenario. A buyer would also need to understand, when do I need those credits, right? And does that sort of allow me does that make it sensible for me to invest in such a project? Because there is an uncertainty as to when credits will be issued. So from a supplier's perspective, you want to make sure that there is a long enough cure period. From a buyer's perspective, you got to make certain sort of that is a cure period you can work with. I know this is a bit of a sort of a generic response, but sort of a detailed response would really sort of require getting a bit more into detail into the contract, which we can happy to do offline.
Perfect. Thank you so much.
Okay. Great. So we had a really good question about adaptability to different jurisdictions. And then kind of in the lightning round here, since we have about 5 minutes left, if we could get to that quickly, then we have also a question for you, the audience, as well at the tail end. So Peter, please.
Right. So we have had a few questions in this respect, adaptability to different jurisdictions. This is now an agreement drafted under New York law. English law is very prominent jurisdictions in CDR transactions. We're working with a law firm in England, Gately Legal, that are in the process of adapting this to an agreement under English law. I'm working on making it, amending it so that it works under German law. So pretty soon we will have English law, German law. The idea is also to get more lawyers involved from other jurisdictions into this project, so that we have, so that it works under at least sort of the main jurisdictions, right? US, England, Germany, Switzerland, Singapore. So that is in the works.
Okay, excellent. Question for you all, kind of turning the tables here for a second. Curious to know, who, what are the clauses that are causing you the biggest pain in your contract negotiations? And if you can speak to that, would love to hear from you about that. And also typical times that we're seeing for you to negotiate contracts. If anyone wants to freely share, obviously if you can't say who's involved, then we totally completely respect that, but we'd love to hear from you. Youssef, please.
Yeah, thank you guys for the very informative session. I think on our end, so one of the biggest challenges we're having is on the liquidity damages. So it's kind of been like rough to make buyers or partners understand, um, that having like too hefty of liquidity damages in case we do not provide the credits at a certain time or things like this could be very detrimental for the company. And we've been in terms of contract duration, like the discussion to actually reach an agreement and sign the contracts have taken anywhere from 6 months to 2 years.
Yeah. I mean, the aspect of sort of, how long it takes to negotiate an agreement like this that's not helpful, right? And this is sort of exactly what we're trying to do with this initiative to shorten that period tremendously. And you said what you're saying is, in my experience, it's very often that, I mean, not very often, it's basically always, that whenever there is an agreement coming from the other side, it always looks different, right? Almost every CDR offtake agreement looks different than the other one. And that makes it sort of incredibly difficult and time consuming to navigate the process. And parties have different experiences and expectations, and that causes a lot of friction that one can avoid when there is sort of a standard and everyone can more or less agree on, like it is in other industries, right? In other industries and transactions, there's sort of a certain standard. I'm always talking about venture capital transactions in the US, at least, where the National Venture Capital Association has published templates for seed transactions that everyone is using, and then there's really no discussion about the terms. Pretty much, I mean, there's obviously details in every kind of transaction, but sort of structurally, conceptually, everyone knows what to expect, and that can be very different in a CDR transaction, and that's something that this agreement tries to remedy.
Great. We were at time right now, but I want to get Nicole Pastricha's questions. Sorry if I'm mispronouncing your last name, Nicole. I can go on for a couple minutes afterwards as well, if you can as well, Peter. Nicole.
Sure.
Hi, Jason. How are you?
Great. How are you?
Good. So I just wanted to mention that there was a panel on this topic at the recent on carbon markets at the PRI in person event in Sao Paulo recently. So that's a group of investors, obviously asset owners and asset managers. And I spoke on this panel and actually talked about this topic because what I said was there's groupings of buyers in the carbon markets, but there aren't really groupings necessarily that are setting their own standards for this type of thing. But there aren't in the same way groupings of maybe investors. So I was an investor audience, but saying the investors haven't come together and said what works for us. I don't know if there's a lot of investors in this call, but I thought it was important that investors weigh in and maybe use something like this to say, this is what works for us. Because what I'm finding is that when we go and we start to do the due diligence on potential investment opportunities, oftentimes they come with the agreements already signed. And then the agreements contain clauses that don't work for us, like some of the things that I think other people were mentioning. Sorry, I forgot the gentleman's name who was just speaking. So if it comes with things like requiring penalties and letters of credit and things that take away our ability to finance the project, then actually I feel like the buyer, who has in most cases no financial interest in the project in the sense that they have not lent any money or advanced any capital, but now they have positions that supersede ours, and we are the ones that are going to be taking the financial risk. So I would really love to see how we could maybe take this template and maybe discuss it with investors further. There was some interest from the PRI group in continuing the discussion that was started in Sao Paulo. because there was a lot of momentum around carbon markets, as you can imagine, with COP and everything, and maybe having like a working group or something. So if there's any way to facilitate that discussion, very happy to facilitate or introduce or make connections to help investors, I think, speak with one voice on this topic. And I think the work you've done is a really great starting point because we don't have to start from scratch and say, what are the terms that would work for us as investors? Not negating the positions that other people have, but as the financial backer of the project, our needs are really important. And if they're not met, it means we can't finance the project.
Yeah.
No, absolutely. And I think we would be delighted to facilitate that because again, you know, what we're trying to achieve really is to get as much market participation and contribution as possible. Financing obviously is a very, you know, it's a crucial element. I mean, an offtake agreement is just one piece in the puzzle, but it cannot exist in a vacuum without proper financing. So both of them need to work hand in hand, and you know, the more people contribute, the better.
Super. Great note to end on, to have next step for what Oscar could become later. So with that, I want to say thank you, Peter. Thank you to Glenn. Thank you to Elena and to Laura on the Oscar team. Thank you to Alex Rink at CDR.FY and the entire CDR.FY team. Thank you, our audience, for having an extremely interesting, informative, and hopefully fruitful session afterwards. As mentioned, this webinar, we are recording it, and so we will work to make that available to you afterwards. With that, like I said, please do look to the CDR FYI site, which I shared a couple times in the chat, for the Oscar document itself. We look forward to hearing your feedback to make this as impactful a document as it can be in the future. So thank you again, and we look forward to seeing you at a future CDR FYI event where we will work through some even more details on Oscar. Thanks, everyone.
Thank you.
Thanks.